this. All right, I think we're good. All right, Charles, can you hear me okay now? Okay, awesome, thank you. Let me go ahead and minimize this, put this up on top, and admit Joseph into the call as well. Awesome. All right, cool. All right, so going back again, the top 3 topics in the contracts that we're seeing a lot going on is seller cancellation of purchase agreement, disputes over earnest money deposit, and then also number 3 is the contingency removal and notice to perform. So what I'd like to share with you is a quick guide on the RPA and the timelines. It's very important.
For first-time buyers.
One second, let me mute Joseph real quick. One of the key elements on the purchase agreement, as I always stress, is knowing the contract inside and out, and the importance in how you deliver that conversation to the end consumer, which is your buyers. Now, the timeline that you are receiving is straight from the California Association of Realtors. But here is an avenue, and if you'd like me to share this with you, send me an email, and I'll be more than happy to send you these diagram documentations to help you understand and navigate the initial process. So 3 days of the DAA, okay? This is the buyer qualifications or pre-approval. This is now part of the new purchase agreement, okay? Part of the new purchase agreement is, the timelines. Back in December of 2021, we had the loan contingency being 21 days. Guess what, ladies and gentlemen? Now it's 17 days. 17 days. But this gives you a good understanding and a good base to understand the timelines on the purchase agreement, because the conversations that will lead to how to diffuse a cancellation of a purchase, how to diffuse a dispute regarding earnest deposit, and how to navigate and negotiate the contingency removal and the notice to perform when and when not to utilize these forms. And again, going back to, you don't have to have 10, 15, 20 years of experience to understand. The purchase agreement lays it out very defined and really like a roadmap. Follow the rules is what I always say. Follow the rules, learn the different timelines, and it doesn't matter who you represent, if it's a buyer or if it's a seller, okay? The timelines are there for that specific purpose, to protect your client, okay? Contingencies from the buy side, contingencies from the sell side, they're all there to protect each and every, and keep everyone aligned. That's the beauty of these forms. Now, diving deep, no one wants to go through a situation or dilemma, right? No one wants to go through the motions of a escrow that ultimately stops in its track, and now we're in negotiations or a dispute itself, and now it's looking towards cancellation, and now both agents that are involved in the transaction is back to square one. If you represent the buyer, now going through the motions of looking and identifying a new property. Secondly, as a seller and a listing agent, putting back the property back on the market, days on market, finding and negotiating with no guarantee and no promise that the seller will get the same price or the same terms. So the 3 days is in the DAA stands days after acceptance, days after acceptance. Okay, so when I talk about the 3 DAA, that's what I'm referring to is the 3 days after acceptance. Okay, so when I say acceptance, that means if the offer was accepted today, today would be considered 0 days of a 30-day process, 0 days of a 17 loan contingency, appraisal contingency, or physical inspections or seller disclosures, okay? Today would be considered 0 days. So what is neat and what are the expectations? when navigating this particular checklist? Well, you know that a buyer's pre-qualification or pre-approval is, days after acceptance. So within those 3 days after acceptance, the buyer and the buyer agent must provide you with the pre-qualification or pre-approval. Okay. Now, common sense, right? Most agents typically, when they submit the offer, they submit the pre-qual already with the offer, right? Typically, but what the contract stipulates, it says otherwise, that the buyer has 3 days to provide you with a pre-qualifying letter or pre-approval letter. Part of the 3 days after acceptance is the buyer proof of down payment, verification of, the finance, right? The proof of down payment. If they're putting a 20% of $1 million offer, you want to verify as a listing agent, this is being proactive, right? Because you do not want to be in a dilemma halfway or close to the end where the buyer does not qualify because they don't have the reserves. Very important. As a seasoned agent, and especially newer agents, you got to understand your position from the very beginning. Be proactive. Days after acceptance also includes buyer deposit to escrow, business days, okay? Calendar days versus business days, big difference. Calendar days interprets Saturday, Sunday, and holidays. Business days does not include Saturday, Sunday, or holidays. So buyer's deposit, business days, because is escrow open on Saturday or Sunday or holiday? They may be internally open, but not for the consumer, if that makes sense, okay? And it all depends on your relationship with your escrow officers, because I know that there's escrow officers that are working behind the scenes on the weekends, evenings, and sometimes even holidays. But if you have that relationship, then you'll be able to wiggle your way into a conversation. But for the most part, most in the general escrow companies are Monday to Friday from 8 to maybe 5 o'clock, maybe possibly even 6 o'clock. Okay. Days after acceptance also includes, and the reason I'm bringing this, because this will lead to the next conversation of disputes, right? When deposits are not in escrow, what's the next step? When the buyer is not performing, what's the next step, right? All these are all elements that you must understand in order to be on track. It's your job and it's your responsibility, to make sure that you're on top. Now, yes, I know that we leverage ourselves and we have our transaction coordinator, right? Or we have an assistant that helps us with the timelines of events. But to be quite honest, it's not their responsibility. Because at the end of the day, you can blame whoever you want to blame, but it's always going to fall back to the licensee. And that's you, and that's your responsibility. Okay. And, God forbid something happens and now the deal falls out of escrow and buyer released all contingencies, right? And you represent the buyer, and now the seller is going after the buyer's deposit. Not a good position to be. But if you're proactive and you're in having constant communications with all the key people, such as the lender, the escrow, and making sure everything is aligning correctly, then you shouldn't have any hiccups. And if you do have hiccups, are you engaged and are you being active in it to make sure to eliminate it as soon as possible or ask for an extension? Now, the cool thing about the contracts, and this is why I have a passion for it, is that, the questions and answers are on the purchase agreement. Just follow the contract. It'll tell you the answer to all of your questions. Okay. And, some of the most common questions is, releasing of contingency. This is where most of the deals fall apart, or buyers or sellers get a little bit annoyed when we have to do an extension, or the buyer's not performing, but they don't want to kill the deal because they haven't got the green light from the lender. So there's many variables that can happen through the initial process, but it's your job is to roll up your sleeves and take engagement in this and make sure that you are in communications. The last thing that you do not want is to not have conversations or communications. This is where people eventually get upset. This is the reason liability happens. This is why complaints happen, because agents out there, not us, but there's a lot of agents that they have lack of communication, and they are not engaged in, trying to nip it in the rear immediately. This is what ultimately leads to liability and sometimes complaints. Okay. Days after acceptance. Days after acceptance also includes buyer or seller's evidence to act in a representative capacity. Okay. This is more if you are a corporation, a trust, okay, or any type of third-party positions. Okay, the buyer and the seller evidence to act in a representative capacity gives you the perspective and the ability to understand all of the elements of what you need to do as part of the process. Seller's request of HOA for common interest disclosure, again, another parameter that you must understand. If you're representing the seller or representing the buyer, you must give the seller the request for HOA for the common interest disclosures within the 3 days after acceptance. Now let's go into the 7 days after acceptance. Seller disclosures and reports to buyer, including the TDS and SPQ. Now this is very important, again, as part of the initial process, that within 7 days after the acceptance, we accept today is 0 days, tomorrow would be considered 1. Here you go. You must, within that time frame, provide seller disclosures. So what happens if the buyer on the 8th day hasn't received the disclosures, right? Well, this is where the buyer has now the right to send a notice to perform to the seller. Mr. and Mrs. Seller, it's 8th day, and by the 7th day, you must have provided us already with all the seller disclosures. We haven't received anything. So that gives the buyer the opportunity to send out the notice to perform, and more so, allows the buyer, if need be, to cancel escrow and back out of the deal. Unilaterally, you cannot just cancel because you just changed your mind. It doesn't work that way. Okay, the only way that you can cancel is if any of the buyer or any of the sellers are in breach of the contract. And being breach of the contract has many different layers and elements to it that you must understand before you actually cancel. You just don't cancel just to cancel. There has to be a breach of any of these elements and conditions in order for any party to cancel. And then after, it has to be mutually canceled by both parties as well. Development or in an HOA, seller delivery a preliminary report, meaning the title report, seller disclosure of any items transfer or lease, such as what do we call it, the solar panels, right? Water filtrations, right? Anything that has been leased or incorporated. And I can also state, like, if it's rental income, multifamily properties, right? These have coin machines and laundries. Sometimes they're owned by a third-party company that they collect rental income from it, from servicing the tenants. And that may also be part of the process that must be transferred to the new buyer. Seller delivery of affidavit of non-foreign status, the FERPTA form, and substitute the QS, better known as the QS, from escrow. Okay. Now the 17 days after acceptance, here are some of the things that you must understand as part of the 17-day process. Okay, buyer to remove of appraisal, disclosure, inspections, and title contingencies. Buyer to return signed statutory disclosures. Okay, now 21 days. Now this was again eliminated as part of the process. This is no longer part of the new purchase agreement. Now the stipulation for removal of loan contingency is not 21 days, it's actually 17 days. So disregard the 21 days and it's actually 17 days. Now the pressure is really on the buyer to perform and the lender to perform. This is why you want to be proactive even before getting an offer accepted. Are you having those conversations with your client? Are you having the conversations with the lender? Is the lender up to par? Are you asking the right questions? Okay. And those questions can be is, what do you think is the time frame to close? Are we going to ask for a 45?
Yeah, I'm watching training.
Hello?
I'm watching Simon's training.
1 second. Let me mute Araceli real quick. I apologize. Thank you, Araceli, for muting yourself. So again, 17 days to release loan contingency is very, very important. And if you need that extra time, then this is where you got to be proactive from the very beginning, 2, 3, 4, 5 days, even before. If the 17-day is not going to happen, then you must ask for an extension of time, okay? 15 days after acceptance, earliest time that the seller may give the buyer a notice to perform for failure to remove contingencies within that 17 item. So this is where it gets pretty interesting, where you want to be proactive, right? You want to be engaged in, making sure that the buyer is on track to release the contingencies. So what it says and what it stipulates is that the contract says it very clear, black and white, that at the 15th day after acceptance, right? 15 days after acceptance, the seller can send the buyer a notice to perform to release that specific contingency. And that could be loan, that could be appraisal, that could be seller's disclosures, that could be buyer's inspections. All right. So on the 17th day, you can send that notice to perform. That allows the buyer 48 hours to perform, meaning that on the 17th mark, the buyer must release it or you have the right to cancel. This is where I see a lot of concerns with agents. They wait till the 17th day, which is perfectly fine. They wait till the 17th day to release that, and they send the notice to perform because the buyer hasn't released a contingency on the 17th day. Okay, on the 17th day. So now what happens is instead of being 17 days, it gives the buyer 48 hours more to release that as a condition. 48 hours more to release those contingencies. All right, so I want to be very crystal clear in our approach and in our position that if you are going to send out a contingency removal or a notice to perform, you can do that 15 days prior to releasing a contingency or 2 days prior to any of the conditions such as earnest deposit, proof of approval of a loan. Okay, you want to be on top of your game, then you can send it 2 days prior the notice to perform. Now you may agitate, you may rub the buyer's agent in the wrong way. It's like, what the heck? We're going to release it on the 17th day. Why am I getting this already sent? And I've had situations and I've had scenarios where agents are getting pissed off that you're sending them the notice to perform. Wait a minute, Simon, you're sending this on the 15th day. I get it. But per the contract, it stipulates that you could send it 2 days before release of contingency. And that's perfectly fine. Okay. Earnest time that the seller may give notice to perform failure to remove loan contingencies. Okay, the 19 days after acceptance. Section 5. Now this is day before close. This is again DBC, days before close. There's days after acceptance, and now we're talking about days before close, the DBC. Now the DBC is 5 days before close, meaning that if you know that it's going to close on Friday, 5 days prior, you can start, sending out these conditions. So 5 days before close, seller to complete repairs. All right. If the buyer sent out a request of repairs, these repairs, if agreed upon between the buyer and the seller, must be done 5 days prior to close. You don't want to be that agent that waits or the seller waits till the very end. Now, scenarios always happen, situations always happen. And one of the biggest stipulations that we see is termite, okay? Termite. And this is, again, you have to be very engaged in the conversation, but more so be very proactive. So the contract says that 5 days prior to close of escrow, you must have it completed. And if not, then you can send out the notice to perform or the extension of time addendum to extend the time for close. So if it's 5 days and you still haven't got the repairs done, then you can ask the buyer or you can ask the seller, depending on what side and who you represent, to give you that extra time frame to close, so that way we're in the position to abide by what the contract states. Okay. Also, 5 days before close of escrow, buyer to conduct their final walkthrough. Okay. The final walkthrough basically states that, you know, if any request of repairs, or if the buyer is still wanting to physically look at the property to make sure that the property is still in the same condition as they originally submitted the offer, or if the seller agreed to do any repairs, replacements of any of the requested repairs, that it has been done 5 days prior to close of escrow. That's where the VP comes into place. The VP, the final verification of walkthrough. Okay. Seller to remove tenants not authorized to stay after close of escrow. Another very common stipulation and counter is that if you are submitting an offer with tenants in place, but part of the agreement that the buyer and the seller agree that property will be delivered vacant, then that must be done 5 days prior. 5 days prior. And this is tenants. This has nothing to do with owners. If the owners are living in the property, they have all the way till close of recording and then some if need be, again, based on the agreement. But when it comes to tenants, okay, tenants have to vacate 5 days prior to close of escrow to be in compliance. And if you're having some issues regarding tenants are still in possession, then you can either do a couple things. You can extend escrow for a period of time to allow the tenant to vacate. Obviously, it may be at a cost to the seller. Okay, I'm just giving you some examples in how you can approach it. Or you can ask the seller to withhold some of the some of the seller's proceed in escrow in order to navigate just in case you have a situation where the whatchamacallit, one second, the tenant is not vacating the property. So again, looking at all the avenues and how you can approach this, you want to be engaged in the communications with the other and the opposing agent to make sure that both of you are in alignment and you're shooting for a closed transactions with no hiccups and no issues. Okay. Any questions so far? So, all right, let me continue here. All right, 3 days before close, earliest time that the seller or buyer can give the other a demand to close. Okay, meaning that either party can give each other the demand to close. So if you know that the close of escrow is tomorrow, and you represent the buyer or the seller, and it's not looking to close, then you must submit the demand to close if you want to, but that jeopardizes the position. So let's just say, for example, that you represent the buyer. Buyer has released all contingencies, everything, loan, appraisal, physical inspections, disclosures, any and all disclosures, all contingencies, and now the buyer's deposit is possibly in jeopardy, right? But let's say there's a delay with the seller and we cannot close accordingly to the agreement on the escrow. What you want to do to protect your buyer's interest and more so their buyer's deposit, set out the demand to close. That gives the seller 72 hours to perform. And if the seller doesn't perform in 72 hours, guess what you can do? You, as the buyer, can cancel escrow, even though you released all contingencies exposing your buyer's deposit. Guess what? Buyer can cancel and buyer should be able to retain their full deposit back. Okay. And a lot of people don't know and do not utilize this particular form, the DCA form, or the DCE form, I should say, the demand to close escrow. Either party can give one or the other this form. The buyer can do it to the seller can do it to the buyer. Now, the jeopardy of the seller sending it to the buyer, if the buyer does not perform on the day it's supposed to record and sell, that's when the seller sends out the demand to close, the DCE form. And if the buyer cannot perform within 72 hours, guess what? The seller has the right to cancel, and the seller may have the right for breach of contract go after the buyer's deposit. Yes, Christine, you have a question.
Hi, Simon.
Hi.
I sent a question in the chat, but for some reason I see Simon on there twice. So it may have gone to your other, I don't know why you're on there twice, but
Okay.
thank you so much. And I'm sorry I'm late. Can you tell me where this form is? That was my first question. I have a two-part question.
This form?
Yeah.
Yeah, this form is right from the California Association of Realtors.
Yeah, I went there.
At the end of the presentation, I can show you, but just go to car forms, go to risk management, and then go to I think it's contracts.
Okay.
And you'll be able to find this form. Or I think even if you just type in RPA timelines.
Okay, I did a search, but I did it on the bottom like you had quick guide. I have a question about what you were talking about with the dates. Can I ask that now?
Yeah.
Okay,
Go ahead.
so when you were saying about, like, I had this issue before and it really caused a problem, but it ended up being okay, and I don't want to get in the same situation right now. When there is a termite, and it wasn't part of the RPA, but it's part of a request for repair. Sometimes if the lender is involved, then you have to have that completion before they're even willing to give loan approval. So how do you protect your buyers, like to make sure that, like the other time I had it, they forgot the date, something happened and they didn't get it done in time. And so we were really in like crunching time that was closing escrow and they didn't have the completion. So we weren't going to fund. So how can you, if you're already giving up, if you have to give up loan contingency, do you have any suggestions?
Yeah, absolutely. I mean, one of the solutions would be is to extend escrow. Is one of the things that I would recommend. It's extending escrow. Now, it all really depends on the situation, because again, if you understand the position as a real estate agent, but you also understand the position as a lender, lenders have a wiggle room to extend the rate lock. And they have where, if you can dive in deep into the conversation, you may have to escalate it to maybe the branch manager or someone higher than the lender to see if they're willing to extend that time frame from potentially losing that rate lock. Now, if you do too many extensions, there's ultimately going to be a cost, and that cost may be something that you can, if it's no fault to the buyer, maybe have the seller maybe incur that cost as well, to allow the buyer to have that time and the seller have that extra time to do so. I hope that kind of answers your question.
Yes, thank you so much.
Okay. What was your next question?
No, that was it. Where's this form?
Okay.
Hey, Simon.
Hi. Okay, cool. Thank you. Thank you. All right, so this is again just giving you an elements of the purchase agreement. Now, what I like to discuss is, the understanding on how a seller can cancel the purchase agreement. Now that I talked to you about, the elements of timelines, right? These are very crucial timelines, knowing the 5 days, the 3 days, 17 days, all those are very important in your position, because this is how seasoned, experienced, knowledgeable real estate professionals know how to get through the process. And this is all about negotiations. Now, let's go into the meats and potatoes and understanding how a seller can cancel a purchase agreement. So, what does a seller have the right to cancel the residential purchase agreement? Now, everything falls regarding the purchase agreement. And what I mean by that, the listing agreement is very vital, very important, because that gives us opportunities to sell property. Disclosures, addendums, request of repairs, all the different contracts that we have are vital. But the purchase agreement is what I call the heartbeat of what we do on a regular basis, because this gives us the opportunity to open up a transaction, open up an escrow. Okay. If you represent a seller, you must get an offer. If you represent the buyer, you're submitting an offer. So this is, to me, the heart of the entire process of what we do. This is what makes dynamic transactions, because the purchase agreement is a very exciting form for me, because you can do a $10 million offer, okay, a $15 million offer, or a $500,000 offer. This is the heartbeat of what we do. And understanding your role regarding the purchase agreement is very vital as well, because this gives you the ins and outs and how to negotiate, how to retract from something, or ultimately modify or add to it. And that's the awesome part of what makes these contracts very, very exciting, because of the element in your position to push, navigate, alter, stop, reverse, right or left, to a certain extent. So part of the process is, again, all that I'm talking is straight from the California Association of Realtors. If the buyer does not remove contingency by the end of the time specified by the form, then you can, and that's under paragraph 14C as in Charles, paragraph 1 of the purchase agreement, that allows the verbiage or the language that allows either party, if they're not performing, to release a contingency to back out. Now, the seller also has that position. If it's a position that the seller must identify and purchase another property as well, okay? So the buyer has the right to exercise their position to push the seller to release that as a contingency, okay? And that contingency is the seller of replacement property, okay? No difference than a buyer on the COP, the contingency of selling their property in order to qualify to purchase their upleg, okay? So both buyer and seller have these forms to ultimately exercise that right. But we're not going to be strung along the process if the seller cannot identify a home or is having a hard time, trying to close the deal. The buyer then has the right to exercise their position to back out during the process. And here's some of the elements that you must do in order for it to do it in a correct way. If the buyer does not meet the specifics on the contractual obligations are specified on the reference, right, of paragraph 14C2. If the buyer does not close escrow, okay, which we talked about the DCE, we talked about, the 17 days of contingencies, right? Remember, it's ping pong, it's tennis, it's soccer, it's basketball, it's football, it's back and forth, back and forth. It doesn't matter who you represent. Your job is to make sure that the process is going based on the contract. Okay, and I have to stress and I have to emphasize the importance of understanding these timelines, because this is what gives you the upper advantage in negotiating the parameters of getting this deal closed or canceled. What if you have no momentum, right? The seller is not being active in their position, and it's making it very difficult to close. Well, then we know either that the buyer may have the right to cancel, or we can escalate it if the seller is in breach of the contract as well. Then there's recourses. And what are those recourses? Buyer can seek legal advice. Buyer has the ability to consult with an attorney to guide them on the next step. Is the seller in breach? Is the buyer in default in any way? It's both parties or one. Then we know how to navigate the position. Are there any preconditions to the seller's right to cancel? Yes, if the buyer fails to comply with one of the circumstances above, the seller must first deliver to buyer a notice buyer to perform, or vice versa, a seller notice to perform, or a demand to close, which is better known as the DCE, whichever is applicable only after the time period has lapsed after delivery of the required form, 2 days for the NBP and 3 days for the NCE, meaning 48 hours for the notice to perform on either party, or the demand to close, which is 72 hours. Don't confuse one, and I get this a lot with agents. I'm confused. Is it 72 hours or is it 48 hours? Notice to perform, 48 hours, buy side, sell side. 72 hours, the demand to close, buy side or sell side. Does the seller have the right to sign an issue of cancellation, CC cancellation of contract, release of deposit, and joint escrow for this purpose? Further, the seller should be in full compliance with the terms of the contract before seeking to cancel. For example, if the seller has not allowed the buyer access to the property, remember, it's a pro and con scenario, folks, meaning that just because the seller is being stubborn, doesn't allow the seller just to cancel a buyer. If the seller is in breach by not allowing the buyer rights to do so, and I'll give you a prime example. You submit an offer, and you submit an offer with no contingencies, none whatsoever. You're going in with no contingencies such as loan, appraisal, physical inspections, disclosures. You're buying the property with none of those, and you submit an offer. Okay, offer gets accepted. Congratulations, you got 30 days to close. During that time frame, based on the contract, just because you released all contingency doesn't mean that the buyer can or is not allowed to do physical inspections. Okay, the buyer still within that 17 days can do as many inspections as they possibly can, meaning home inspection, termite inspection, sewer inspection, electrical inspections, roof inspections, chimney inspections, foundation inspections, okay, garage inspections, whatever the case may be. They can do as many inspections as they want. And specific inspections, right? Like putting a camera in the sewer line to make sure that there is no cracks or nothing is blocking for the sewer waste to go down to the sewer lines in the city connection, right? All that is part of it. A seller cannot say to the buyer, Mr. or Mrs. Buyer, because you released all contingencies, I'm not going to allow you to do any inspections. You released that, you're buying the property in its as-is condition. Well, then that's when the broker will step in and disagree with the listing agent and the seller and say, no, you are wrong. You're incorrect. Just because the buyer released it doesn't mean that the buyer cannot do their due diligence, okay? And that's a very important statement. They have the right to do their due diligence regarding the property, okay? They have the right to go in there and physically go and do an inspection. And it may not be a contractor or a home inspector. Maybe it's just the individual buyer that wants to go and see the condition of the property. You cannot stop that, because if you do stop them, then you are in breach of the contract. You're in breach of the contract. We have a question by Charles.
Yeah, I have a question. Is that the case even if in an addendum or a counter, they specifically state there will be no access allowed to the buyer?
Run that by me again, Charles. I'm sorry.
Sure. Can you hear me?
I can hear you.
Okay. Yeah,
I
the
can
question.
hear you better now.
Yeah, the question is if the buyer signs a counter or an addendum before opening escrow that says that the seller requests no access, or the seller allows no access, or there will be no access during escrow, does that 17-day thing override whatever's in the counter? Or
Yeah, very good question. Now, when you start altering these contracts, okay, and I encourage you not to start modifying, leave the contracts alone. It's funny, a lot of real estate agents like to practice law, and they say, well, we want to modify based on what the seller's request. Now, if it's a direct question that the seller is requesting no entry and you put that in writing and the buyer signs it, then technically speaking, you're now altering the purchase agreement. And if the buyer and seller mutually agree to it, then the answer is yeah. The buyer then unfortunately signed off on waiving the rights to physically enter the property. But the contract stipulates that the buyer has the right to do any entry to the property 17 days. Now, if you alter and say buyer will not do any inspections or will not be allowed into the property, that's really the buyer's decision. Now, bear in mind, folks, if you are putting that type of specific language, you're setting yourself for liability. Because here's what can happen. If the buyer goes and agrees to those terms, buys the property, closes the deal, and the house falls apart, someone passes away, someone gets hurt, they're going to go after you. They're going to sue. I can promise you that's going to happen. Why is, well, the seller's going to say, I specifically said that they were not allowed to go into the property. The buyer released all contingency, and part of the stipulation that we added to the addendum instructed that that was the case. Now, they're always going to side for the victim, okay? The victim would be, in this case, the buyer. The buyer would be the victim in this, and I can see this going all over the place, okay? It is best to allow the buyer entry to the property. It's best for the buyer to allow them to do whatever they want within the time frame. This avoids liability. This avoids lawsuits. This avoids complaints coming in, okay? And most of the brokers get the blunt of these complaints. Do the right thing. And if you have questions, always, get the advice from your team leader or your broker, okay? Because their license is also on the line for you. If you go down with the ship, guess what? The broker goes down with you as well. You don't want to harm or hurt the broker, whose number one goal is to protect the company, protect the agents, and making sure that the agents are doing the right thing. But to answer your question, Charles, if the language is stated, buyer and seller agree and sign and execute it, then yeah, the seller can say, nope, you're not allowed. You signed it. Here's the agreement. Okay. So I hope that kind of answers your question.
thanks. Yeah.
All right. Well, let's go ahead and continue. The seller need the buyer's consent to cancel. The seller has the right to unilaterally cancel the contract if the procedure described above is followed and the buyer has failed to act in accordance with the contract. And again, buyer or seller can be in this position. However, cancellation of escrow will ordinarily require mutual instruction from the buyer and seller. Let's just say, for example, folks, okay, you represent the seller, you accept an offer on a buyer with their agent, and part of the process is that the buyer puts in the earnest deposit, right? And 3 days come in and nothing. You don't get the money. Escrow calls, hey Simon, we haven't received the buyer's deposit. You send out the notice to perform for the buyer to perform, and the buyer still is MIA. They're not responding. The agent is not responding, and you're in limbo. You have what you thought an open escrow, but you have no communications. You send out the notice to perform. Buyer did not perform. rightfully the seller has the right to exercise their position and cancel. Now, cancellation has to be mutually canceled between both the buyer and the seller. The reason for that is because say you cancel, but you don't have the written consent or the authorization or mutual agreement from the buyer, you now go open escrow with another buyer. This buyer says, hey, wait a minute, Simon, I never canceled. And I'm still in the position to buy. We still have an open escrow. Then therefore, you may be in a situation where this buyer, buyer one, can send a lease pendants against and alter and stop the process from you selling the property to another buyer, even though this buyer has better price, better terms. I caution you in your position. When that happens, please reach out to the broker, ask for advice and guidance. Now, there's ways in how you handle this to protect you and your license, and more so the scenario from a seller being in two escrows, because this happened to one of our agents several years back where we represented the buyer. The buyer submitted an offer contingent that the cancellation of the first escrow, and they got their offer accepted. They went through the motions of doing their inspections, and then halfway through the escrow, the buyer who was originally in escrow got an attorney, put a lease pendants against the property, and stopped the sale from the second buyer, which was our client, from allowing them to close the deal. So now our clients ended up getting an attorney, and it was a chaos now against the seller, because the seller had two open escrows. Even though the seller and the listing agent say, while the buyer was in breach, they did not fully perform, we had the right to exercise and cancel. And it was back and forth for 4 months. Buyer and buyer ended up going through a mediation to try to see if they can mediate, but the first original buyer was gung-ho that they still wanted the property. So after 4 months of tying up the buyer's deposit, they just decided to release and say, you know what, I don't want to deal with this because our money's still tied up on this. Let's just go find another property and open escrow, which they ended up doing so. And, that can happen. So from a listing perspective and you representing the seller, you got to be very careful. If you're getting into that, in that gray area, bring the broker involved, and ultimately there's some options we can do. If you're getting no communications from the listing agent, from the agent in general, then we escalate it, get the broker involved. The broker will reach the manager or the broker from that brokerage and try to diffuse it and be proactive to get someone else involved in this. It is their responsibility because their license is also in jeopardy. They're going to be proactive and engage in the conversation. And you know how many times I've been able to resolve situations because I escalated to the broker of record or the manager or the team leader to diffuse the situation and get some momentum, get that spark going where the buyer is. And that's where, again, the support that we have here as well. May the seller keep the buyer's deposit after cancellation of contract, okay? This is where I get a lot of questions as well. If the buyer cancels, can the seller go after the seller's deposit? Well, it depends. It really depends. Okay. And then I'll ask that question is, well, tell me how far you're in the escrow process. Okay. Has the buyer released all contingencies? Okay. Has the buyer breached any other process of the contract? Okay. Once I know some of the answers, then I can tell you, yeah, the seller may have the right to go after the the buyer's deposit. So if the seller cancels after issuing the notice the buyer to perform, requires the seller to typically return the buyer's deposit. That's under paragraph 14C1. The RPA takes the approach of a contractual trade-off by providing a clear guidance on when and how a seller can cancel the dispute over whether a buyer has breached in material or not, and thus whether the seller would have the right to cancel or avoid. In return for this clarity, the seller also is obligated to return the deposit if the seller cancels after issuing the demand to close of escrow. The RPA does not automatically require the seller to authorize return of the buyer's deposit. In such circumstance, the facts of each situation will need to be analyzed on their own merit. Sellers should consult, obviously, with the legal counsel before making a decision about the deposit after issuing a demand to close or the notice to perform. Now, it's very clear and concise, folks. And what I mean by that is, if the buyer's in breach of the contract and you've done what you have done, then it's very clear. Okay, you cancel, you move on, and you find another buyer. Or if the reverse, if it's a seller, then buyer cancels and you go find another property. Now, where it gets a little tricky is when the buyer, where the seller cancels and the seller is wanting to go after the buyer's deposit. That's where it could get a little bit sketchy and a little bit of concern. If the buyer has not released any or all contingencies, then the seller does not have the right to go after the buyer's deposit. You have to return the money, and it's your job and your responsibility to address that to the seller, letting the seller know, Mr. and Mrs. Seller, in all due respect, I understand you're frustrated with the entire process with this buyer. He's been streaming us through the entire process with, obvious some concerns. And now, we're in the position where we have to cancel because the buyer is backing out. Well, the seller is going to be very upset with that. But if the buyer did not release contingencies, we unfortunately have to give the money back to the buyer. Just, it is what it is. Now, if the seller feels that they were in breach of the contract, then there's no meeting of the mind, then the seller doesn't mutually have to agree with the buyer's position. And therefore, until we have meeting of the mind, mutual agreement, then that's when the money will be released. If the seller feels that they've been taken advantage or they've been cheated from money because they did all the repairs and now they've been damaged, then ultimately you escalate it to a mediation. A mediation is a third party, either experienced or licensed mediator that will hear both sides of the story. And ultimately the job of the mediator is to come to an agreement or compromise, or ultimately go back to the original agreement and cancel and release the money. Now, there is a cost for a mediator to be involved, and that can range from anywhere from $300 to $400 to even $500 per hour. But it's cheaper than hiring an attorney and getting demands and all that stuff. Now, if we cannot come to a resolution under a mediation, then you can escalate it into an arbitration. And that's, again, part of the contract is your liquidated damage provision, paragraph 36, 37 of the RPA, and your mediation arbitration position. If you initial those, then you agree to mediate, you agree to arbitrate as part of the process. Now, going back to the arbitration process, if we cannot have a meeting of the mind, then either party can take it to that next level and get an arbitration hearing. No difference than going to small claims court. It's the same process. It's usually at one of the local boards. It can be in the local boards of the South Bay area, the San Gabriel, wherever there's a board. It's a mutual location where a mediator will hear the case. An arbitrator will hear the case, and ultimately that's when you'll have an opening statement, a cross-examination, and then a final rebuttal to articulate your position, and then you present your case and all the evidence. Within 20 to 48 hours, the arbitrator will make a decision, and then who he or she decides is the winning case is ultimately the winning, and you cannot rebuttal that after. And then obviously, if you do not sign the mediation or the arbitrations, which most attorneys don't, then ultimately what happens is that you can hire an attorney. an attorney can draft a complaint letter and then ultimately see if they're willing to step up and return a rebuttal on what their position and the reasoning why this halted, stopped, or why we have this dispute. And if not, then they can escalate it into, a complaint and ultimately take it to court and have a judge hear it. Again, it can be very pricey because as much as I know, that attorneys charge, anywhere from $450 to even $500-600, depending on who you hire. And then that's just to hire the attorney, plus all the pushing of papers, setting up all these depositions and whatever it takes. Now you're looking in $1,000. Is it really worth it if there's a, $5,000, $10,000, $15,000 deposit? Maybe not. Now, everyone is different and unique in their position. We as real estate professionals, we cannot, tell them what directions. We can just give them those options and let the buyer or the seller make the decision on how they want to approach it. This is where we step back and then have them speak with an attorney and have the attorney advise them on the next position. Okay. Any questions regarding cancellation of purchase? All right, let's continue real quick on contingency and removals, which was the third topic of today's lesson. What is a contingency? A contingency allows a buyer or seller to cancel a purchase agreement based upon, the happening of a certain event. By default, all of the purchase agreement contains contingencies for loan appraisal, title disclosures, and investigations. Must a contingency be removal be in writing? Okay, the answer is yes. Yes, it must be in writing. Anything and everything that we do, ladies and gentlemen, must be in writing. Anything verbal will not hold water and will not hold water if we have to take it and escalate it to a arbitration or even possibly court. You must have paper trail. Okay. So under the purchase agreement, all contingencies must be removed in writing and signed off. Until that happens, the buyer or seller will retain the right to cancel based upon open contingency. Going back to what I said, if there is no release of contingencies, therefore, you cannot go after the buyer's deposit. Now, no difference than a buyer and the seller, there has to be some type of skin in the game. This is why a seller requests the buyer to put some deposit for the purpose of holding the property out of the market for a 30, 40-day escrow. This is why the buy-in for the buyer is, Mr. and Mrs. Seller, we want this property in good faith. We're putting the property on hold while we go through the motions of getting the finance or proper money to close the deal. So you're tying up the property. This is the reason the seller will typically have the buyer put a deposit. Now, it's common practice in our industry, and that minimum deposit should be 3% of the purchase agreement. Now, that's not the requirement, but that's the most that the seller can go after if the buyer breaches the contract and the buyer doesn't perform after releasing all contingencies. Okay, so I want to be very clear that if buyer doesn't release contingencies, buyer gets the right to get their deposit if they don't perform and close the deal. So don't be that agent that doesn't follow the rules, because I've seen agents don't follow the rule and now they are in hot water from the sellers. Is we were 45, 50 days in escrow and the buyer never released all contingencies, and now the buyer's canceling, and you're telling me that I cannot go after that 20,000 for holding my property for 60 days? Are you out of your mind? The answer is yes, unfortunately, because we didn't ask for the buyer to release all contingencies. The buyer has the right to cancel, and the buyer has the right to get their deposit. It's unfortunate. This is why don't lag it, folks. Don't lag it. If the buyer's not performing, nip it, cancel, move on. It's best to find another buyer than string along this buyer that may not perform. This is, again, going to the first topic of timelines. Okay. I hope I make myself very clear on this, in the importance of our positions. Don't the contingency expires after 17 days? Yes and no. The contingencies are not waived automatically, folks. After 17 days, however, elapsed of the 17-day period allows the seller to deliver the notice to perform, giving the buyer 2 days to remove contingency. Here it is. Contingencies are not automatically released, meaning that if on the 17th day it falls off, okay, it has to be in writing. The buyer, per the contract, has to be the one releasing. Guess what? Buyer and buyer agents are going to be hush hush. They're not going to, just release that contingency, and more so physical, more so appraisal or loan contingencies. They just won't. They're going to write it as much as they possibly can until the seller says, hey, Simon, we haven't released the loan contingency. What's going on? It's already 25 days. We're about to close. What's going on? All right. Shame on you. Shame on you for not being diligent. Remember what I said earlier, send that notice to perform 15 days in, so that way on the 17th day, the buyer has to release it. Otherwise, you have the right to cancel. Follow the rules, follow the timelines, folks. Very simple. Don't get emotionally entangled in this chaos of the process. Now, if there's wiggle room in there, both agents are, working really well, then yeah, there's certain things that you can bend a little bit, okay? But when it comes to the contracts, those should not be bent. Those should be, like I said, black and white. If they need the extension, ask for the extension. Sorry, Simon, you know what? The buyer cannot, for some uncertain reason, cannot release the loan contingency. We need another 5 days. No problem. Let me talk to the seller. Seller says, okay, what's the reason? Well, the buyer says, the agent says the buyer cannot release the loan contingency because there's some documentation that the underwriter is still reviewing. They're asking for 5 additional days. Do you want to grant that extension? You know what? They've been okay. We'll grant them the extension to release that contingency. Fantastic. Okay. Go back to the buyer's agent. Hey, I got good news. Buyer, seller has given and granted the extension. Send me the ETA form, the extension of time addendum. That allows the extension to release that as a condition. Now, Simon, do I have to send another notice to perform on the 5th day of that extension? The answer is yes. Yes. Remember, contingencies don't automatically get released. So on the 5th day, you're going to send on the 3rd day that contingency notice to perform to release that as part of the process. And at that time, remember, you're putting pressure so that way you can corner yourself and be the hero for your sellers, okay? That's the awesome part of what we have here, okay? So any questions regarding that?
Simon, I have one question. Before releasing the contingency for inspection, and you do an inspection and there's work to be done, you don't release the inspection contingency for inspection. You negotiate to have the property repaired. Is that correct?
I'm sorry, can you repeat the question again, Joseph? My sincere apology. I got the
No problem.
fan or the AC here and it's hard to hear you.
No problem. It's a hot day. Let's say you have certain amount of days before you release your contingency on inspection. Before that, you have the sewer done or termites, and you find there's a problem. You don't release the contingency on that, but you demand for repair or credit towards that before you release the contingency. Is that correct?
Yeah, that is correct. Remember, everything is a negotiating tool. And the way I put it into better perspective is very simple, Joseph, is I always presume that this is more like a carrot and a camel. If you put a carrot in front of the camel, okay, the camel will follow that carrot. If you move that carrot to the left, the camel will follow the carrot to the left. If you put that carrot to the right, the camel will follow that, right? No difference than in our position. Remember, any way you finesse this, it's again your control over who you represent. It doesn't matter if it's the buyer, it doesn't matter if it's the seller. The position that you put yourself in is like that carrot, okay? And being proactive. But to answer your question, yes, sir, that is correct.
Thank you. I have one follow-up question. before releasing the contingencies, let's say the repair goes beyond the timeline to remove the contingency, whether they have to get someone to repair it or whatever the case may be. So you ask for extension, or how does that work in that case?
Yeah, that's a very good question, Joseph. Thank you for sharing. So remember, any and all agreed upon repairs must be done within 5 days of close of escrow. So it doesn't really matter if the buyer releases that as a condition 17 days. The seller still has 5 days prior to close of escrow to have that complete, because the buyer has 5 days to do their final walkthrough of the property. That's when the buyer will go into the property and see, okay, you took care of that, you took care of this, you took care of that, then I'm going to sign off on the final verification that the seller did as agreed, and we're moving forward. This is the reason you have the VP form, the verification of final walkthrough. If there's something that is a concern, you're going to draft the verification of final walkthrough and say, well, this hasn't been taken care of, item 1, 2, and 3, and 4. Now you're going to present that to the listing agent, but you're also going to send this to the escrow and say, Miss Escrow Officer, we have a situation here, and we have to delay the process from closing because the seller has not completed the the request, and therefore we need extra time to close. Remember, the engagement in the position of being proactive is your responsibility, so that way everything falls into place. At the end of the day, whatever the buyer and the seller want to do, it's up to them, but your job is to go back to the contract.
Thank you for asking that question. My other follow-up question is, do you release contingencies even though repair needs to be done if they do the repairs within the liable time, or how you don't release the contingencies till they do the repairs? So how does that work?
That's a two-way position, and here's my position on that. I would advise, and this is just me, I would advise the seller, okay? And now I'm putting my hat as a seller agent, right? Selling, meaning I'm the listing agent, but the seller. Yes. What I would say is to the seller, look, Mr. and Mrs. Seller, yes, you agree to repair certain items on the property, but we're not going to do any repairs until the buyer releases that as a condition. Because if the buyer doesn't release that as a condition and you do the repairs and you spend $10,000, the buyer decides to back out, you're out $10,000. Now, it may be a good thing because that may be something that the new buyer, but remember, all properties are sold in as is condition, meaning that the seller doesn't necessarily have to. They're doing it for the benefit of helping out the buyer. But I would encourage, if you are representing the seller, that don't do any repairs until the buyer releases all contingencies. Now, with that being said, 17 days from a 30-day period, that's about 2 weeks to probably take care of majority of the buyer's request of repairs. Now, if it's an extensive request, then you may have to push the escrow to allow, but you still keep the contingencies at the same time, 17 days, because now buyer has released any and all contingencies, buyer backs out, you spend $10,000, but there's $25,000 deposit. Guess what? Now the seller can articulate his position. Well, here's the receipt that I did, and I'm going to go at least for $15,000 because I replaced the AC as an example. That cost me $10,000. I had to pay another mortgage because we were supposed to close in 30 days, but now we extended that time. So now I'm going to go after another $3,500. You see where I'm going with this? This is why it's very, very, very important that your position, right, is that the buyer release all contingencies, because now it's exposing the buyer's deposit, and now there's more skin in the game for the seller to do the repairs. Because I would hate for the seller to do the repairs, buyer never released the conditions, and now buyer backs out, and the seller just spent that amount, which wasn't necessary. I hope
that explains very well. Thank you very much, Simon.
My pleasure, Joseph. Thank you. All right, last, and then I have to cut it loose. If seller cancels after delivery of a notice the buyer to perform, is the seller entitled to keep the buyer's deposit? The answer is no, folks, no. The contracts are very clear in its position. A seller who cancels after the delivery of the notice to buyer to perform must authorize the release of the deposit back to the buyer. And that's under paragraph 14C1, folks. And of the RPA, the most typical scenario is when the seller might retain the deposit if the seller canceled for failure buyer to close escrow after buyer has removed all contingencies, okay? Remember, in order for someone to go after for damages, one has to be in breach of the contract. Just because the buyer cancels and the seller is upset doesn't give the right for the seller to go after the deposit. There has to be a breach. And that breach was a way how you can position and ultimately articulate your position for damages. Okay, I hope that kind of makes sense. All right, and yes, this was recorded and it should be posted as well. So any final question before we cut loose for the afternoon?
Thank you, Simon, again.
My pleasure. All right, team, thank you very much for jumping on the call. And if you have any questions, by all means, please reach out to your broker, reach out to me. I'm here to help and here to serve.
Thank you so much, Simon.
All right, thank you.
Thank you.
See you later, guys. Bye-bye now.
Bye-bye.
Oh, that was great.